World. Hello, listener. What's important to you about what's going on in your community? Are you interested? Are you concerned? In any case, I invite you to tune into my show, Seattle Here and Now, on Rainier Avenue Radio World. Why? I will be covering a wide range of topics important to you and impacting the community. Each show will have a special guest or guests to share with you information on a variety of subjects that are happening here and now in Seattle. I promise I will work hard to make my show informative, interesting, and entertaining. Be sure to listen to Seattle Here and Now on Rainier Avenue Radio World.
Northwest Film Forum's Collective Power Fund is now open for grant applications. Grants are starting at $2,000 up to $10,000 for individual or artist collectives. The annual grant cycle focuses primarily on supporting art that incites public dialogue, pushes boundaries, explores genre fluidity, speaks its truth through an authentic perspective, and is often non-traditional, anti-institutional, socially responsible, or disruptive of any existing structures and conventions. Learn more and apply at collectivepowernw.org.
You're listening to Rainier Avenue Radio World. Check us out on social media. Facebook and Instagram, Rainier Avenue Radio World, and on Twitter at Rainier Ave Radio.
Welcome to Rainier Avenue Radio. This is Afternoons with Monique, recording live in Seattle, Washington, every Thursday at 1 p.m.
Good afternoon, Seattle. This is Monique from the Afternoons with Monique show, and you are on Rainier Avenue Radio. Today, I have the pleasure of welcoming a top jurist in Washington State. Justice Helen Whitener was appointed to the Washington State Supreme Court in April of 2020. She's been on Afternoons with Monique and Rainier Avenue Radio a few times before in previous campaigns. And this year, she is running again for the Washington State Supreme Court. Now, Justice Whitener was the first Black woman to serve on the Washington State Supreme Court and the only Black LGBT judge in the state of Washington. Prior to sitting on the state highest court, Justice Whitener served as Pierce County Superior Court judge and also served as a judge on Washington State Board of Industrial Insurance Appeals. Please help me welcome to Afternoons with Monique, Justice Whitener. How are you doing, Justice Whitener? It's been a while.
Can you hear me?
Yes, I can hear you now.
I cannot hear you.
No? Let's see if I can change that. Can you hear me now? No? How about...
I'm not hearing her. I see they said in the... Yeah, my volume and everything is up, so it's on their end.
In this program that they're in, see if your mic is on.
Oh, your mic is muted, Monique.
It is. Okay, how about now? Can you hear me? No?
I'm not hearing her.
Yikes.
You can hear me?
Yeah, Rainier Avenue Radio can hear both of us, but for some reason, I hear you.
Let me see. I have a different mic on.
I can hear you, but I'm not sure that you can hear me right now.
Settings. Audio.
You might have me on mute on your keyboard. Do you want to check that?
I wonder if I should put on my headphones. Let me see. That will help.
That might help.
Because I can't hear her.
The speaker, volume, and headphones. Yeah, let's try the headphone. So while the justice is trying to listen to me, I'm going to share with the audience a little bit more about her background. Justice, whenever you can hear me.
Yes.
Okay, you
Yes,
can
I
hear me
can
now.
hear you now. Hi.
Wonderful. Okay.
Good
Well, you've been on
afternoon.
my show a couple of times before, and you've been
Yes.
serving on the Supreme Court for some time now. So let's get right to it because we only have 25 minutes to the show. So,
Yes. Yes.
update us. What surprised you about the serving on the Supreme Court?
Very good question. I think what surprises me, Monique, is the level of support I've received since getting here and the level of support that are given to appellate judges. Because you remember, I came from the Pierce County Superior Court, a trial level court, and I get to the Supreme Court, and I was used to doing everything myself, to include writing my own opinions and delivering my own opinions. And I get to the Supreme Court, and there is so much support. You have law clerks, you have reporters, the clerk's office. It's just amazing, but it makes sense because we have so much work. We have commissioners. There's so much work that if the justices had to do the work, we would not be able to take any time to even sleep.
Wow. What have you learned that you did not know before besides the level of support that you've received from staff members?
The appellate process.
Oh, really?
Yeah, the appellate process, because I have been entirely, my entire legal career, a trial level judge. Mm-hmm. I actually have the unique perspective of having been a prosecutor, defense attorney, and judicial officer on the municipal court level, all three roles, the district court level, all three roles, and then superior court, all three roles. Mm-hmm. So I knew the trial court work intimately, but I get to the Supreme Court and it's appellate review of the trial level court or the Court of Appeals work. Right. And that is just fascinating because now I see what they were looking at in regards to my record. You know, I was used to making the record as an attorney and then as a judge, making sure that record is secure. But I get up here and now you see what the record looks like and how the appellate level attorneys argue their perspective. And then you have to make a decision based on the law. So It's fascinating. It's really fascinating.
I am a little bit familiar with that process, actually. Yes. I know about the numbering and indexing and referencing is meticulous when it comes to appeal, and you have to reference all the evidence that the trial court give you and identify the issues. So it's a totally different ball game.
Yes, because if it's not in the appellate record, I don't get to see it. Right. So that's why I remember as a trial court judge and an attorney, it was about making that record because once it's gone from the trial level, the appellate court is limited by that record. Right. Now I understand what that means and how significant it is for trial level work to make sure that record is complete and secure.
Wow. Now, you've been on Superior Court judge right before you became a Supreme Court judge.
Yes.
Do you enjoy serving on the Supreme Court more than Superior Court?
I enjoy the law. I get immersed in the law, period. So I remember when I was an attorney, folks would ask, well, what kind of attorney do you want to be? I don't care. I just want to be in the courtroom. I want to do trials. I want to be with the judge, talk and everything.
Right.
And now that I am on the appellate court, I realize I just really love the law. So going through the record, formulating a decision, understanding the different perspectives and I'm humbled by the power, vested in Supreme Court justices to come to a decision that impacts, so many people. But we're really restricted by the rule of law and what the law stands for. And if it's not in there, go to the legislature and hopefully they give us something to work with. So I stick within the rule of law.
Excellent. Supreme Court, Superior Court, different, and the appellate court is probably more like the Supreme Court in that it traced the records back and it documents everything and its name and reference and all that. So are those the key differences? The effect it has, the Supreme Court has on people's life and lawmaking. Does it? I mean, you mentioned legislation and the changes that has to be made through that branch, but does the Supreme Court has any immediate change and that affect people's life, or does it take a little while for that to trickle down to the population that they would feel the effect of your and your colleagues' decisions?
Well, it can be immediate. It depends on what it is, but you have to remember the Supreme Court, the state Supreme Court, is the final arbiter on state law. So once a decision comes out from the Supreme Court, the state Supreme Court, the lower courts need to follow it. And if they don't, it comes back up on appeal and then they get slapped. It's like, no, you need to follow this.
Exactly.
Does that mean we're always correct? No, because we're human. But that's where you also get majority opinions and dissenting opinions, because we're human. We sometimes don't agree on the interpretation of that law, you know. So there are many differences between the two processes. One is creating the record for review, and the appellate level is reviewing that record to see if it comports with the law.
Right. On your current accepted cases list as of April 2022, you have 8 cases that are not yet ready and 4 that are awaiting.
Before you finish that, it's not my cases, because I have cases that I have assigned. So the court's cases, because I'm very particular, I try to make sure my decisions are timely and everything else. So no, what I heard you reference in there is going to be the court's cases.
Right, the 9 panel, the justices. So you have 8 cases that are not yet ready and 4 that are awaiting a setting. A dozen cases in the queue appears to be an all-time low for the Washington State Supreme Court. So since you are accepting very few cases, this has always been that way, how do you make of the few cases that are currently being accepted for review by the Supreme Court, the Washington State Supreme Court?
If the number is low, as far as the number of cases we're accepting, there are a number of factors that could really work into that. First of all, the Supreme Court is, as I indicated, the highest level review court. So we can't accept all reviews. That's why we even have an intermediary appellate court, which is the Court of Appeals, and we have 3 of those. Those that actually make it to the Supreme Court are in the thousands. We can't review, and when I say we, the 9 justices can't review thousands of cases. So we actually have a clerk's office that then reviews those, and then it goes on to our commissioners who really screen those cases. Right. And narrowing it down, you are actually narrowing it down based on the requirements for review. So yes, you can file a case for a review in the Supreme Court, but if, let's say, it's not a case that is of substantial public interest, not just public interest, but substantial, that's the type of cases we would take. Because it can touch on the state constitution, the interpretation of the state or federal constitution for that matter. Then you could have cases, let's say, because we have 3 Court of Appeals, and they make a decision that conflicts with our decision that we have out there, our precedent. Then that's something we would need to look at, because remember, we are the final arbiters on the law. What we say goes. So if the Court of Appeals is doing something different, then that is something that is worthy of review by the sitting justices.
The higher court.
Yes. Another example is, let's say the lower court makes a ruling that conflicts with our laws. Then that is something as well that the Supreme Court can look at. So it's not just every case. There are actually a requirement for review of the Supreme Court. And then from those, you get oral arguments and then we hear the cases, but we can't hear thousands of cases.
Absolutely.
We can't even hear hundreds of cases in a term, even though that many may come in. It really is trickled down to those that touch on our Constitution, that touch on interpretation of our laws, those sorts of things. It has to be of substantial public interest.
Right. I know that you've been on the Supreme Court for like a couple years, but you probably know in past years, let's say 20 years, what's the average number of cases that would be reviewed by the Supreme Court on an average year?
Since I've been here, we've heard probably a little less than 300 cases, about 200 and some odd cases. And my understanding is that number has gone down from what the court normally hears.
Right.
And I would say this, it's probably because of the times that we're operating under. Because think about it, we hear cases that are coming from the lower court. If the lower court isn't operating, and I'm getting to the pandemic, if our courts are closed or we have reduced the number of cases our trial level courts are hearing, then that's going to reduce the number of reviews that are coming up. And then remember, we still have to go through, are they worthy of Supreme Court review? Right. So that could be a reason that we're actually seeing less cases at the Supreme Court level, seeing that I'm the what I call the virtual justice. I came in a virtual platform, and I'm still in this virtual platform. So that could be one of the factors I would think that's impacting those numbers.
So since you have not heard too many live cases, and in the lower court, they also have not, limited. I'm not even sure if the court reopened for live trials at this point. My understanding that is still through Zoom. And you have to review those records. Have they gotten up to your level yet, those Zoom trials? Yeah, we've had, I now know what you're talking about. You're talking about the remote trials utilizing the Zoom platform. I don't believe we have any of those that have made it up yet, but more than likely they will be. And they will be for a number of reasons. Now, to correct you, I have heard live arguments. I just haven't heard any in-person arguments. I don't want folks to think that, I haven't seen any live people. No, I've heard live interviews. I just haven't had any in person. So I've never sat with my colleagues at the Supreme Court to hear oral arguments, which gives me actually a very unique perspective on that and whether or not, remote arguments are somewhat different than in person. Yeah. Right. And the trial courts, they have these remote session where 12 jurors would be listening to a trial, a hearing. Do you think that it would affect those jurors' ability to make good decision, considering they have distraction in the home, there are 12 different screens, and listening to the minutia details of trials, the nuance of the arguments from both sides? Are there things that get lost in translation when you go through a medium like that? In other words, does not being able to confront the accused, the accused have a chance to confront the accuser live and in person and direct, do you feel that it would lose its transparency and authenticity of a trial as a judge sitting on, the bench, or as somebody that would review the records like yourself?
You have so many things in that question. I'm going to break it down as best as I can. First of all, premising it with, we're utilizing technology in a way it was never utilized within our courts before. And it's impacting access to justice in a way that we've never envisioned before. So having said that, I'm going to be limited in how I can respond, because this is the first time our courts have been tested by utilizing this technology on the level it was used, both for civil and criminal cases. So I don't want to recuse myself from those cases, so I'll be very careful in how I answer your question. But having said that, I want you to understand that having been a trial level judge for quite a few number of years, because I pro tem before becoming a judge as well, we always had access issues in regards to jurors hearing cases. So a blind individual would be in the courtroom and can't see what's going on, but still can assess credibility. And that's what's important. And that's probably where the issues that arise will be focused on, because the question really comes down to, on the trial level, depending on the type of case, did it impact either side's ability to present their case, as well as comport with the constitutional rights of the defendant, because there are rights to do certain things, to face their accusers, as you indicated. But does that mean it has to be in person, or can it be via, a medium such as remote? So those things are issues that our courts are addressing and have had to address during the pandemic. And I'm sure there are cases that are challenging the use of those mediums that are trickling up. It'll probably be slowly because there's a backlog, but they'll be trickling up. And I think they will be fascinating issues to address, because technology is the future, but we have to make sure the use of technology does not infringe on an individual's constitutional rights. So there's an access as well issue. But then we also, because I am also someone who identifies with a disability, which is why as I listen to your question, I realize I have had jurors who had hearing impairments. Did that affect their ability to engage? I would say no. Right. I've had jurors who were sight limited. Did that affect? So those are the things we're going to have to struggle with within the law, and addressing access. And then we have issues in regards to economics. You're utilizing a platform, and are you going to excuse a juror because they don't have, the Zoom, or even, let's say, a phone that they could use, or, a laptop, those sorts of things. And if they don't have it, is it the court's responsibility to provide it on their accommodations? I mean, fascinating. The law is in a fascinating place right now.
I never thought of those scenarios where, yes, blind individuals, disabled individuals, they are part of the community, and they also have the right to represent that juror, the 12 jurors in that box. So interesting perspective. Thank you for that. What Supreme Court decision are you most proud of during your service so far?
All of them. Everyone that I wrote.
Of course.
But I love... Well, I recently had a decision come out probably a week or two ago, Mays v. Spokane, and it had to do with the restrictive covenant issue. It was a Spokane case. And the reason I like that case is because I was able to discuss the history, the historical significance of historic events that should not be destroyed or eliminated. It is very important. We may not like the history, but it is history. And history is important so that it's not repeated. What would have happened to us if the Holocaust was not documented? What would have happened to us if slavery was not documented? I would be sitting here talking about stuff, and you'd look at me and go, that never could have happened. Yes, it did. So it's important. And I was able to at least put those lens on that case and receive a 9-0 decision. The first case I got at the Supreme Court was another one where my lens, I believe, came into play, State v. Jackson. It was a case about the court using shackling of defendants without making an independent analysis as to whether shackling was needed. Shackling from the court's perspective should be a security issue. And the court interacts with the jail, and the jail has its own different protocols that it has to comply with, which is, security, but escape and those sorts of things. And what was happening is some judges in our courts were deferring to the correctional officer's decision to shackle without making an independent decision analysis as to whether the defendant who is before them should be shackled. And that case was significant because as a Black individual and understanding the historical significance of shackling during slavery, I thought putting that lens on that was important, and I received a 9-0 on that. And what's interesting there is the defendant was a Native American man. So it had nothing to do with just slavery. It had to do with the dehumanization of individuals within our courts and our judges needing to exercise their discretion by independently analyzing those issues. So those are two. And then the last one I would think of is Aquavella, and that is a 40-year water rights case brought by the Yakima Nation. And I was able to finalize that case for them. After 40 some odd years, there were about 5 different opinions over the 40 years, and being able to work on that, it was extensive.
So you're proud of all your written decision. How about, and I'm talking about the 9 justices panel, because you have insight into those decisions more so than me or the average person. I don't even follow the published opinion as well as closely as these appellate and Supreme Court attorneys that go in front of you typically. But it's always fascinated to me to follow once in a while cases. What decision that may concern you in the last couple of years that you've been on the bench?
I don't get concerned by decisions, and here's why. I operate within the rule of law. It's something I learned real early as a pro tem judge. I don't make things personal. I stick to the law. I'm so marginalized that I don't get caught up in causes. So when a decision is made, I respect it. And I respect the 3 branches of government. In my own writings and in my own decisions, if I have concerns, I flag them in my decision. I stick within the rule of law, but I flag them if I cannot interpret them the way I would like to see it interpreted. I have to stick within the law. I don't legislate. So I flag my concern in my decision for the legislature to go take care of it so that we don't have that problem anymore. But I can't say I honestly get concerned about things. And if there's a concern that I have, I write a dissent. I love doing that now too. I have a dissenting voice, something I never had before.
Do you keep track of your concurring versus dissenting decisions? Do you know how many right now?
I've never signed off or written a concurrence, but I have about 4 dissenting opinions and about 15 majority opinions so far.
Okay. The Supreme Court has been breaking new ground in its avowed efforts to end racism in our legal system. Do you believe it is possible for the Supreme Court to end racism in our legal system?
No. Do you understand that question? No. If that was the case, it would have been taken care of probably under Justice Thurgood Marshall. But here's why I don't think, based on your question, that we have the ability to solve racism. Because racism is something that's within the society at large. But I do believe the 3 branches of government can work on trying to make an impact in addressing racism within the different institutions that we have. Racism as well is multidimensional in that I'm such a marginalized individual, Black, female, immigrant, lesbian, person with a disability. But racism impacts each one of those societal labels in a different way. Racism also impacts homelessness, environmental issues that come up in our society, housing. So can we solve racism? No. But can we make a difference by addressing it within the institution that we're working within? Yes. And the way we can do that, first and foremost, is acknowledging that racism exists. The second thing we can do is understanding that we have to be a little transparent, which makes us vulnerable, but that goes both ways. You cannot get white individuals who are supposed to be the power structure. You cannot get them to assist you or become allies if you're attacking them. You have to get them to empathize and understand the impact racism has had on you if you're speaking as one, and if you're speaking as a collective group as such. But the court solving racism. Good luck with that, Monique. I would love to see that.
We can only hope, but however, I understand your point. It's important to hear the justice point of view on it, and I have to ask those questions. Thank you so much for joining me on my show, Afternoons with Monique, Justice Whitener. It is the end of my show. Yes, it's a pleasure, always. Okay, so next week we are going to have Sephoriana Day from Upper Left Strategies PR on. Please join us on Thursday, April 14th at 1 p.m. on Rainier Avenue Radio. Thank you, everybody. Signing off.